May I have my Lord's indulgence to, in very unusual circumstances, mention a matter. This is a public interest litigation. I am for the private party. It's directly basically against me, although the state is the party. They said, it was listed before my Lords on the 7th of this month.
What is the issue involved?
Setting up a cement plant, illegal mining of coal and such things, my Lord.
Yes.
So they've challenged the cement plant, setting up the cement plant. I'm the owner of the cement plant. So this had come before my Lords on the list of 7th. Your Lordship may recall that at the last moment, 7th was declared as a local holiday. And therefore, my Lord's list of the 7th obviously could not be taken up because that day it was a holiday.
Yes.
Now, it is not showing in the list on any day. I was only making this humble prayer. If your Lordship adds it to the supplementary list tomorrow, then I can make a prayer for fixing of a date.
Let it appear as to be mentioned
Tomorrow.
because you are there for the other matter, that spirits matter.
So we'll fix it. Your Lordship will fix it together.
And please ask your advocate on record to notice all.
I will do that immediately.
All parties.
So it may appear tomorrow as to be mentioned. I'll just give the first. Please. Grateful to one.
Item number 1, announcement of judgment.
Sorry.
We have held that the reversion of the respondent to the original post was wrongful. We affirm the impugned judgment and order and dismiss the appeal. MC 68 is also disposed of.
Number 2,
Outline.
Yes.
My Lord, as regard of the PIL that
Speak a little louder.
my Lord, as regarding our PIL, regarding the difficulties faced by us, who following the Nyamkasi faith and worshipping the deities called Kalayo Kalayhat and the Puri in or goddess Devi in the Hindu religion. At Shibling, which is there as Maujimbun Cave, Mausundam, Eskasil district, our ancestor has been worshipping the said Shibling since time immemorial, and the said Shibling has also been worshipping by the people who following the Hindu and also all the Sanatan Dharma faith in Bharat. And every year, our people go there during the sacred month of Navatri and Sawan to perform puja to the deities in the said Shiva Lingam at the Kremajimbun. Our Lordship, all this year in the past, there is no issue in the matter to performing the puja as per the tenets of our religion and visit the said religious place. However, in the year 2016, when the Nyamkasi go there to perform puja, the district administration and the village government start to interfering our tenets of religion by creating problem and threaten our life and disallow our Nyamkasi to perform puja in this place. They don't allow also to enter the premier without the permission by the way illegally collect money in the name of the entry fees and restricted people for performing puja. That the government of Meghalaya and the devotional Mosundam and pressure group has started interfering with the Maujimbun Cave only with the intention to stop us for performing our puja in the sacred place. My Lord, this Im Mausundam has already handed over this declared land at Mojibung Cave, where the Shiba Lingam situated to the Senkasi Himamosundam. By way of land MOU or agreement dated 14 May 2015, and the same has been registered under Revision Act 1908 for its management, control, and supervision, and also for the just practice as per the tenets of our customary law practice of the Khasi tribe, who follow to our own faith and culture. However, in spite of that, the Governor Mosundam, Chief Mosundam, along with the government of Meghalaya, has started interfering and illegally try to take control of our land at Mojibung Cave so that they can stop the puja in that said place. My Lord, there is a threat to our life, especially for me, if I go there in my own village. In 2016, my life is in danger, and what is make me very sad when I look at state government take over our land in 2019. When I file a complaint, some anti-social element has come in my residence in Maulai around 11:50 at night and threatened me to withdraw my complaint. And after that, I received also the letter, written letter, and I wrote an FIR.
Community can be post facto cancelled. Let us take it up and see what happens.
And I wrote an FIR, and the FIR has been registered. Instead of that, the government filed FR in the district and the court, and I filed an objection, and the court passed an order to reinvest the case. However, the police have issued me 41A CRPC. With that 41A CRPC or 41A CRPC should be issued to go there.
All right, we are admitting the petition.
Yeah.
But, you do not appear in person. You appear of legal aid and engage somebody to appear for you.
Yeah. So we can, if you not allow us to appear, we can manage also sir, by our
All right, please take it.
by our organization also we can. My Lord, if you allow, we can, our own organization, we can manage, we can seek fund also for that.
You can?
We will take our help from another Hindu community also to help our people.
No, you will be able to engage a learned lawyer.
Yeah, we seek
All
help
right.
for that.
Considering the fact that law of general importance in this state is involved. And also the financial constraint faced by the petitioner law of general importance concerning tribal rights. We treat the letter dated 24th March 2025 of Senkhasi Hima Mausinram to the Chief Justice. As a petition in the public interest litigation field. Full stop. We direct the registry to register it. Full stop. We admit the same, comma, keeping the point of maintainability open. List this public interest litigation on 12th May 2025. The petitioner is to serve copies of this petition the Chief Secretary, Government of Meghalaya, the appropriate district council, no, Khati Hills Autonomous District Council. The secretary in charge of land and registration of property, within the jurisdiction of Khasi Hills Autonomous District Council. And all other stakeholders. All right?
Thank you, my lord.
Number 3.
Please, George.
Yes.
Lordship, this is a petition under section 37 by Power Grid.
This is number 4.
Sorry, I'm sorry, ma'am. I'm sorry.
Number 3, my lords.
Yes.
My lord, I'm seeking some accommodation in this matter today. My lord, I'm for all the respondents right herein. My lord, my senior counsel is leading this matter. Bhaskadev Kaur is having some personal difficulty today, my lords. I'm only paying for refixing this matter. After service of informal paper,
You're for the appellant or respondents?
for the respondents, my lord.
You're for the appellants?
Yes, sure.
Paper book has been filed,
Yes, my lord. I will ask you. This first time it has come after the filing of the paper book.
so it is ready for hearing.
Yes, my lord.
It's ready for hearing, Lordship.
He's asking for adjournment.
Lord,
I'm
yes,
afraid
correct.
you're asking for adjournment.
When should we keep it?
Any date you prefer.
My lord, may I pay for a fixed date, my lord, on 23rd of next month, my lords.
23rd May?
Yes, my lords.
No, not. Too long adjournments are taken in this court. Take a short adjournment.
My lord, may I pray 16th of May, my lords.
Make it middle of the week, 14th. 14th or 15th.
In that case, 9th of May, my lord. 9th.
Why on a Friday? Because we cannot finish a matter.
My lord, 5th or 9th, any date as per my lord's convenience.
Yes, and if it is not finished on 5th, we will take it up on the 6th.
My lords. A small matter, it will be over, my lords.
Agreeing for 5th.
By consent of learned counsel for the parties, this appeal is fixed for hearing on 5th May 2025.
Wait, my lord. Next.
Number 4,
May 3 years.
Yes.
Lordship, power grid is an appeal in section 37 before your Lordship, and the issue is very short one, my lord. If your Lordship kindly see your Lordship's order of 9th December 2024, my lord, 9th December order
This is ready for hearing.
is ready for hearing. There are 3 claims, my lord, which we are challenging, my lord. Claim number 2, claim number 4, and claim number 10, my lord. And very short issue, my lord. Claim number 10 is the shortest, my lord. Claim number 10 relates to the return of bank guarantee, my lord. The claim of the petitioner was to return the bank guarantee because bank guarantee was never encashed. Even in their own claim petition, issue was confined to return of bank guarantee. What learned arbitrator has done is, my lord, that directed the petitioner to pay the amount because we have never encashed the bank guarantee, and that was not also issue before the learned arbitrator, my lord. Learned arbitrator has, if your lordship will kindly see, issue before the learned arbitrator was, my lord, at page 119. Award starts from page 108. Only 3 claims, my lord. The learned arbitrator framed the issues at page 119, my lord, and page 129, my lord, it dealing with the bank guarantee, my lord.
Page 1.
129, my lord. Award starts from page 108, my lord. issue number 4, my lord, at foot of the page of page 129. Claimant, as per terms of the contract, executed the bank guarantee of 33,71,695 and issued by the State Bank of India. And see, brother, thereafter, claimant extended the bank guarantee, my lord, and after recording the entire history, my lord, at page 130, last paragraph, the claimant, while later dated 21st March 2015, turned down the proposal for extension of bank guarantee on the ground that request was beyond contractual provision, and respondent have already issued for taking over certificate on completion of the work. The factual matrix highlighted above shows that validity of bank guarantee was extended up to 24th February 2024, even long after completion of the work, and issued for taking over certificate dated on 31st. Therefore, further extension of bank guarantee as requested was not required since the final bill was awaiting release. Therefore, the extension of bank guarantee cannot be sustained. Issue was extension of bank guarantee. Prayer was also, my lord, release of bank guarantee. If your lordship will kindly see the prayer of the claimant at page 154 and claim number 10, my lord, at page 155. Second last claim, my lord, of page 155. Claimant is entitled to release of bank guarantee. Claim number 10, my lord, claimant is entitled to release of bank guarantee. So the claimant was seeking release of bank guarantee, and the learned arbitrator, my lord, at page 158 has awarded the amount, my lord. Claim number 10, your lordship has marked at page 155. So this is error apparent of the face of record, my lord, patent illegality, because issue was release of bank guarantee. We have never encashed the bank guarantee amount, and the learned arbitrator awarded the bank guarantee amount, my lord, at claim number 10, page 158, my lord. So the learned arbitrator could not have, my lord, because we never forfeited the bank guarantee amount. And the prayer was also release and extension only. I have shown at page 130, my lord. So this is a case of clear patent illegality on the part of the learned arbitrator in awarding the amount, so far as claim number 10 is concerned, my lord. Now there are two other claims, my lord. Claim number 2 and claim number 4, my lord.
What has the learned trial judge held?
Trial judge did not deal with this issue, my lord, at all. In 34, it is not dealt, my lord. But the fact of the matter is, my lord, that there is no encashment of bank guarantee. It is not even the case of the claimant that
You challenged this in the 34 petition.
34 petition, my lord, entire award was challenged, but we are confining our challenge only to 3 claims, my lord, claim number 2, claim number 4 and claim number 10, my lord, and to that to a very limited extent, my lord. Claim number 10, no forfeiture of bank guarantee amount, therefore the learned arbitrator could not have awarded the amount, even there is not the claim of the claimant also, my lord. So that on that point, my lord, it is a case of patent illegality and covered in the 34 2A of the Arbitration and Conciliation Act, my lord. If your lordship will see also the very strange manner in which award has been authored and written, my lord, kindly see page 119, my lord, page 119 where issues have been framed.
No, what about the other claims?
The other claim, my lord, is my case was, if your lordship has already recorded, that we have retained only 22,60,174 rupees. Whereas, if your lordship will see, that is clear from claim number 2 at page 155, my lord. 154, your lordship, kindly see the bottom. Now, how the learned arbitrator has addressed these claims also, because no discussion, nothing, and straight away, amount has been awarded without examining the challenge. 154 bottom, your lordship will see just above claim number 1. We may now address the different claims raised by the claimant. Now, claimant is entitled to so and so being the balance of final bill. We are not challenging this part, my lord, but no reason. Claim number 2. Claimant would be entitled to release of 33,50,845 deducted from 6 running account bill at the rate of 5% while granting extension. Now, in claim number 2, my lord, I have said that we have deducted only 22,60,174. And you see page 200 of my 200 which we have taken below. And this is also not refuted by the claimant that the deduction is moot.
385 is outstanding, 200 is
385, my lord. $385, where we have said that the deduction is 385 at 386, my lord. And we have given the details of deduction. That is at 22,60,174. And the learned arbitrator, without any reason, said you pay 33,50,845. No discussion, my lord, at all. And we have given details how the money was deducted, and it has also not been refuted. 386, if your lordship may kindly see. $386 bottom, my lord. Deduction is 22,60,174. The amount shown by the claimant is wrong, and the amount withheld and deducted by respondent towards LD retains the money, and other is 22 lakh.
But what reason the learned judge has given?
No reason in the award. What is, if your lordship, no reason, lordship, no reason at all. Even not adverted to.
Argued.
It was argued, my lord. In fact, it was, that's why 386 is my pleading, where I say that this is the, I have deducted only 22,60,174. And the claimant has also not denied that deduction is to the extent of 20. His claim in the SOC, my lord, if your lordship will see the statement of claim, at page 200, which was replied by me at 386, that the figure given is wrong. They say 33,50,845, and by detailed chart at 386 I say I have deducted only 22,60,174. The arbitrator should have given this only 22,60,174. We have no objection in giving 22.
Which is the other claim?
And the other claim is not similar. If you also will see page 155 once again. Claim number 4. Claimant would be entitled to 47,39,450 as retention money deducted from 6 running account. No reason is given, and I say, my lord, that I have deducted only 31,17,736, which your lordship will find 388, where I have said so that figure, and I have given details, my lord. So my case,
So how much?
31,17,364. Deduction is there, and we have given how the claimant is wrong in giving those figures also at 388, my lord. The arbitrator has not given any reason why the amount sought by the claimant should be paid, my lord, when I have showed by the material and evidence that my retention is to the extent of 31,17,364, my lord. So these are the only 3 objections I have against the award, my lord. One, with the bank guarantee, which I have not encashed. Second, retention is to this extent only. And in other aspects, I am not challenging the award, my lord.
So this is also not discussed in the order.
This is not also discussed, my lord.
Yes.
Your lordship may kindly come to page 86, that's section 34 petition. No such type of specific issue raised by them. The general statements made while challenging the arbitral award. Now they are raising the specific issue, my lord. So, which is not permissible on the merit, my lord. Now regarding the claim number 10, my lord, here I will satisfy with the release of the bank guarantee. Bank guarantee in fact has expired. So that amount is, I think, inadvertently included in the arbitral award regarding the bank guarantee. Regarding the claim number 2, my lord, your lordship may kindly come to page 386, my lord. They are saying they are disputing this amount, but in fact they have admitted this amount. Claim number 2, my lord. Page 386, there is statement of defense. They are justifying the deduction on the merit, but they are not denying the claim amount, my lord. First line, page 386, my lord. The respondent state that deduction of rupees 33,50,845 has been made as per provisions of the contract. On the merit they are justifying, and at this stage the award cannot be challenged on the merit, my lord, merit of the claim. It is well settled law, your lordship knows. And regarding claim number 4, my lord,
Same.
yes, claim number 4, my lord, our claim is 47,39,450. So this is relating to the merit of the award. At this stage they cannot challenge. Moreover, they have not specifically challenged the under section 34 petition, my lord. They are coming in this honorable court with new plea.
Where have you shown that the amount is 33 lakhs and not 22? How have you dealt with this?
Because I have also at page 202, my lord, regarding claim number 4, the deducted amount from various running bills I have mentioned here. Breakup is given there. Page 202, my lord.
Who is the learned arbitrator?
Honorable Justice D. Biswas.
Retired Justice D. Biswas, my lord.
Retired district judge?
No, retired High Court judge.
High Court judge.
Where here?
Yes.
From
Honorable Guwahati High Court judge.
Guwahati.
Name?
Justice D. Biswas.
159.
We'll send those two claims on remand and bank guarantee we will set aside.
Only one page, my lord. My friend has shown 386, my lord. Kindly see, my lord. 386. Because 386, your lordship will kindly.
You see, Mr. Kumar,
Yes, my lord.
under the law which you know,
I know.
then
I know. I have.
we can't rewrite the award.
I'm not, your lordship. What my case is, my lord, that I said that they have not denied this part, that I have deducted only 22 lakh rupees, my lord. That is the
That
page.
is all right. Suppose we accept their denial, we have to rewrite the award?
No, my lord, to the extent if the award is not giving reasons, award is patently illegal under third, because I have said that I have only deducted 22 lakh rupees, and award has not uttered a single line, my lord.
No, if we set aside the award, try to understand, they will get nothing.
No,
They should get 21 at least.
22, I am ready to pay 22, whatever a retained amount, my lord, I have no issue. I will, to that extent, lordship pass the award that whatever is retained amount, I will pay to them. They are not entitled to over and above which I have not retained, my lord. That I am conceding, my lord, that they are entitled to 22 lakh 60,000 and they are entitled to 31 lakh 17,000. And I have given the details and that has not been dealt. That this is the,
If he agrees to it, it is all right.
No, my lord, in claim number 3, they are admitting this amount.
no, that is what I want to show.
Lordship may kindly come to page 3.
We have understood, but we cannot neither adjudicate.
I have not asked, my lord, what I say, my lord, your lordships will interfere within the realm or within the ambit of section 34, my lord. Now 34, I have filed the petition.
He will say, I will get 21, which is admitted amount, plus 31 minus 21.
No, your lordship, that's, I'm sorry, I'm not.
Now, to uphold your contention, we have to award them, we have to restrict it to 21. Now, to uphold their contention, we have to add 10 and give them 10. So, which means rewriting the award like an arbitrator.
No, my lord, that I'm not at all asking your lordship to do it. What?
So, the admitted amount you pay,
Yes.
the disputed amount will go on a remand. Let the learned arbitrator decide.
Yes, my lord. I have no issue, my lord. Admitted amount I pay, my lord. And there is one small is 9 also, a lordship 80,000. That also a lordship remand.
No, my lord, they confined. By order of this honorable court, they confined on claim number 2, 4, 10. Now they cannot add any other claim at this. This
If your lordship kindly see page 150.
No, Mr. Kumar, don't.
is not a practice.
Leave it. Because it is emanating from claim number 10 only. That is why. Bank guarantee. 155.
That is for maintenance.
What they are saying, claimant is entitled to release your bank 10 million.
9.
9. 155. The claimant is entitled to 81,6,114 bank commission paid by subject to production of bank vouchers. Million. That also because the arbitrator is saying he is a functus officio, sir. And that too also after he has become, he says subject to Milord. So this issue also, Milord, because they have not produced any bank vouchers also. Subject to production, amount is awarded, no bank vouchers are produced. For what? For maintaining the bank guarantee. And there was no maintenance also. Sir, kindly see 155.
We are setting aside the award with regard to bank guarantee.
Yes, grateful. Sir.
Please take down. Considering the short issues involved in this appeal and the utmost cooperation this court has received from learned counsel appearing for the parties to dispose of this appeal by making very fair submissions. We have been able to hear out this appeal today and dispose of it at the very first hearing. Paragraph. The dispute between the parties is with regard to the award in respect of claims 2 4 and 10. In claim 10, the respondent asked for the release of the bank guarantee for rupees 33,71,695 dated 1st April 2014. Issued by State Bank of India, Fancy Bazaar Traders Branch, Guwahati. By his award dated 20th September 2019, the learned arbitrator has directed the appellant to pay to the respondent the value of the said guarantee. Next, admittedly, the bank guarantee was never encashed. Full stop. Upon its expiry, it was discharged and returned to the appellant. Learned counsel for the respondent confirms this factual situation and admits that this award was made by mistake. So, treating this error as one apparent on the face of the record, the award in respect of claim 10 is set aside.
Only the amount, my lord. Because release of bank guarantee, I am entitled for release of bank guarantee. Only awarded amount may be set aside.
Yes.
Yes.
What else you will get?
Yes.
Bank guarantee document has been discharged, yes. In claim 2, the respondent asked for release of rupees 33,50,845 allegedly deducted from 6 running bills at the rate of 5% by granting extension of contract. According to the appellant, the amount retained was 22 lakhs.
22,60,174.
22 lakhs 60.
60,174.
Retained was 20 lakhs 60,174.
20.
Learned Advocate General on behalf of his client, he is prepared to give an undertaking to return this admitted amount. However, learned counsel for the respondent maintains that the retention money mentioned in the award is correct. Now, this court cannot go into the factual dispute. With regard to the retained sum. Neither can be. To rewrite the award by inserting the correct sum. Also, we think that in the facts and circumstances of this case, the ends of justice would be subserved if rupees 22,60174, the admitted amount, is paid by the appellant to the respondent within 4 weeks from date. We order accordingly the disputed amount bracket rupees 33,50845 minus rupees 22,60174 may be re-adjudicated by the learned arbitrator, especially in view of the submission made that neither the learned arbitrator nor the trial judge has addressed the issue nor given any reason for making the said award. Paragraph. Our direction is similar with regard to the award in respect of claim 4, which is similar in nature, which is similar in nature to claim number 2. The claimed amount is rupees 47,39,450 and the admitted amount is 31,17,364. We direct the appellant to pay the admitted amount 31,17,364 to the respondent within 4 weeks from date, full stop. The disputed amount 47,39,450 minus 31,17,364 is also remanded to the learned arbitrator for re-adjudication for the same reasons as claim number 2. The learned arbitrator is directed to publish, is requested to make and publish a supplementary award within 6 months from date. The award as upheld by this court may now be enforced.
Lordship, we have paid the amount, my lord. Your Lordships kindly see 28th October's order of your Lordship. We have deposited 95 lakh before your Lordship. So balance amount we will pay within, after deducting the bank guarantee and the admitted amount, we will pay within 6 weeks we will pay the entire amount.
My lord, we will be allowed to withdraw the amount deposited by them before this honorable court.
We will pay,
Yes. Already you have paid.
yes.
So what will be the net award after this?
Your Lordship, we have deposited before your Lordship this total amount, we have to deduct this bank guarantee amount that comes to 33,71,695. And interest has also been, interest has to go on that part also, my lord. So we will work out and pay the amount to this.
Excluding the bank guarantee, the payable
And the
amount
admitted amount, admitted.
after adjustment, it will be around 1 crore. So we will make the calculation, my lord.
Where are awards executed here?
Before the commercial court, my lord. We have one commercial court for whole state, my lord.
We will say can maybe enforced by execution of the award.
Yes, sir. Yes, sir.
Maybe enforced by execution of the award.
Or otherwise, we can sit together, my lord, and we can find out the actual payable amount. That will be better instead of going to execution court.
Or mutual arrangement between learned advocates and record for the parties.
Yes, yes, ma'am.
But 90 lakhs is deposited with whom?
With your lordship, the 95, we direct the appellant to deposit a balance of roughly 95 lakh with the Registrar General of this court by 11th November 2024. So that has to be released to us so that we can make the payment.
The advocates of record for the parties are appointed joint special officers for the purpose of receiving the deposit of rupees 95 lakhs with the Registrar General of this court from further to an earlier order of this court.
Paid them 40 lakhs also.
They shall open a joint account to be operated jointly in State Bank of India. Give the name of the branch near High Court. Huh? And the said sum of rupees 95 crores will be deposited there by the joint special officers. Full stop. The fund, wholly or partially, is to be used to satisfy the award.
Yes, my lord. And we have already paid to the claimant, my lord, 40,76,226. Over. We have already paid that amount. So
That we will take care.
To satisfy the award, or that portion of it which remains unpaid.
yes, my lord. That portion.
The balance, if any, shall be refunded to the appellant.
Yes, my lord. The award is upheld to the aforesaid extent, my lord. Your lordship has said award is upheld to the aforesaid because your lord, with the consent of parties, your lordship has set aside the one part.
What was it? The award is? Oh, I see. We have said set aside now. The award is upheld to the proceedings.
Grateful, Lord.
Upheld and set aside to the proceedings.
Yes, madam. Yes. Grateful.
It's partly upheld and partly set aside to the proceedings. Thank you.
Thank grateful, madam.
That's the fixed matter.
Item number 7 and 8.
The other matter will be taken up tomorrow. Yes, Mr. Sir.
I will, my lord, today be showing to your lordship, my lord, the judgments on which I seek to rely. My lord, just before that, my lord, just to, my lord, give your lordship, my lord, a precursor to why I am showing these judgments. When your lordship remember that, my lord, I have already argued the section 19 point. What remains to be argued is, my lord, Article 14 violation and, my lord, Article 19. My lord, because we had said that this amounts to creation of a monopoly.
Yes.
Now, my lord, so far as Article 14.
Article 19(6), two provisos you had shown us.
That's it.
To Article 19 and 19 to be read with Article 14.
Right. Now, my lord, so far as 14 is concerned, the grounds on which, my lord, 14 comes into play, my lord, are the grounds which we have, my lord, identified in the supplementary affidavit of 14 September 2021. Well, that is what has happened there. So, my lord, we have ultimately, well, lordship, just to give your lordship a brief background, well, your lordship will remember that, well, this ultimately, well, does not, well, allow for any price provisioning for the CPW. That's number one.
Yes.
Number two, well, the CPW has been, well, created not to perform any extra or additional function or any new function. It performs the same functions that, my lord, the bonded warehouses were to be performing. Now, the bonded warehouses have, my lord, been retained. So, my lord, we have just added one step to the process without, my lord, creating any new, my lord, set of circumstances or any new purpose or any new service that is to be provided. Now, my lord, therefore, we have, my lord, persons, my lord, who are supposed to provide similar services. And, my lord, you are now creating, my lord, a difference here between, my lord, persons similarly situated. The next aspect of the matter is, my lord, here if your lordship will see, my lord, we have, my lord, very categorically provided that, my lord, there are no checks and balances that are available in the system. Why? Because number one, my lord, very, very important to the whole scheme of things is, my lord, ultimately making my products available to the retailers. Now, my lord, previously, as your lordships have heard me, previously the bonded warehouses, my lord, depending on, my lord, their situs, will, my lord, determine what is the demand for particular products and, my lord, place the orders for these products on the, my lord, distillers or bottlers. So, my lord, ultimately, it is the market demand for, my lord, specific regions in the state where the respective bonded warehouses are situated that would ultimately reflect in, my lord, orders being placed on the distillers, bottlers. Today, my lord, it is not that. Today, my lord, this ultimately will have to be done at the instance of the CBW, the Central Bonded Warehouse. Of course, my lord, there is something which says that the bonded warehouses will, my lord, ultimately, my lord, escalate their demands to the CBW and the CBW will then place the demand on the bottlers. But, my lord, there is no, my lord, provision that is made as to how, my lord, the stocks will be, my lord, maintained. For example, it says you shall maintain 3-month stock. Whereby what is 3-month stock is not maintained. How the 3-month stock is determined is not maintained. But this apart, my lord, here, so far as the question of pricing is concerned, I have showed your lordship the instance of, my lord, the response. That ultimately, here we have a situation where the upstream and downstream is both controlled. Because, my lord, the persons who constitute the CBW today are also persons who own bonded warehouses and also distilling and bottling plants in the state. So, my lord, to ultimately pitchfork the demand of their units, well, there will be, my lord, extra credit facilities that are made available to these units. my lord, no credit facilities available to my lord, other my lord, distillers, bottlers, or my lord, other bonded warehouses. And my lord, this apart, ultimately, my lord, easier credit terms, discounted rates, and my lord, here, when the question was posed by the court earlier, as is recorded in one of the orders, they come forward and say that yes, I'm sorry.
Yes, please.
There is a difference, but the difference in rates we are charging from one bonded warehouse or other is on account of, my lord, the freight charges. For example, one may have to carry freight, my lord, for a larger distance, one for a shorter distance, so on and so forth. So ultimately, there is an admission of two things. A, my lord, that there is, my lord, a demand made at one point of time, which of course now has been kept under suspension because of your lordship's observations in the course of hearing of the matter. For, my lord, ultimately CBW commission of about 17%, because that is built into the 25% that was demanded. And secondly, my lord, there is also, my lord, admission of the fact that, well, different prices are being charged from different entities, bonded entities. So, well, all these are, my lord, factors which have been very clearly identified in the supplementary affidavit. I do not wish to separately travel.
Tell us one thing, Mr. Shah, that while judging the validity or validity of a notification, Mr. Banerjee also,
Yes.
can the court issue directions for implementation of the notification?
Ordinarily, no. Because then, my lord, the notification is accepted. My lord, then the question of virus no longer remains valid. If, my lord, the notification is to be implemented, then, my lord, the question of virus goes. Then, my lord, the notification is accepted as a part of, my lord, the legislative mandate which has to be followed.
For example, please show the notification.
Well, if you will also kindly have a look at, well, can you give me a moment? Yes. Well, the notification, well, the bonded warehouse notification is at page 43 of the writ petition.
Of the writ petition.
Yes, ma'am, of the writ petition.
Like for example, 13.
Yes, ma'am.
The central bonded warehouses or ex-bond rates of all the imported goods shall be subject to approval by the Commissioner of Excise, etc., etc.
Well, this was also the position previously prevailing. So, my lord, the ex-bond rate is fixed by the Commissioner of Excise. Now, my lord, the ex-bond rates would accommodate within it, my lord, the distillers and bottlers rates, and, my lord, the bonded warehouse commission of 8%. Today, that ex-bond rate will have to accommodate, my lord, distillers, bottlers rates, bonded warehouse commission of 8%, plus whatever is the central bonded warehouse commission, which they have reflected in one of their correspondence will be around 17%.
We can't say that the ex-bond rate would be as if this notification was not made at that rate, not more than that.
Well, the ex-bond rate is, my lord, something that has always been fixed by the Excise Commissioner. Now, let us say the ex-bond rate is 100. Previously, my lord, out of that 8 rupees would be the commission paid to the bonded warehouse and 92 to the distiller.
We can understand that the ex-bond rate would go up.
Yes.
And the demand would come down because of the rate rise.
Either it affects my price or, my lord, it ultimately passed on to the customers where the demand, my lord, falls. The price increases by 17%, the demand falls.
So can we not say that you can appoint a tier of bonded warehouse owners or whatever, that is your discretion, but the ex-bond rate would be, cannot increase what it was prior to the notification or at the market rate.
Well, the question would still be,
without taking into account the increase in the number of bonded warehouses, etc., or appointing a central bonded warehouse, or creating a central bonded warehouse. etc.
But if the central bonded warehouse goes, then the entire purpose is served. We say that the central bonded warehouse is not required at all. Does not create any additional purpose, does not provide any additional service.
That is your additional point.
That's it.
Yes, the point which I was trying to drive home was that the central bonded warehouse would have to eat out of the existing commission amount and not increase the bonded price rate.
Well, so far as that existing commission amount is concerned, I'm just trying to understand your lordship's query. X bond rate remains 100 as it was. The distiller's bottlers price is not affected. The bonded warehouse commission is not affected. The question is then, as your lordships are pleased to observe just now, out of where does the CBW commission come? Then the CBW will function without charging any commission. That is what it will ultimately translate to.
No, because you are appearing for the manufacturers.
Yes.
So whatever commission the others will get may not be your concern. But if we say that in your rate that the commission, the X bond rate would have to remain the same.
Well,
Out of that, the central commission, the other bonded warehouse, etc., the central bonded warehouse, whatever they take commission is up to them.
that would respectfully not ultimately serve the purpose, because this commission will then be passed on. It may not affect my rate, but it will be passed on to the customer, which will mean the price of my commodity increases significantly, which means there is a fall in my demand. So that is how it will be affected. But apart from that, the entire scheme of these notifications is unconstitutional. Because it is a notification which is not required, it is a notification which creates a monopoly, and it is a notification which ultimately is without any checks and balances. And why it is without checks and balances, I have outlined in significant detail in my affidavit of 14 September 2021.
Yes.
Now here primarily, if your lordship will kindly see, just to illustrate my point, please see the notification since your lordships have opened it. Please see clause number 9. Now the central bonded warehouse shall have the capacity to supply and deliver to all the registered brands of IMFL, beer, VIO to the bonded warehouses within 45 days. For goods produced in state in 60 days for goods imported. I am pausing here for a moment. So what this really contemplates is that a bonded warehouse will place an order on the central bonded warehouse, which may be supplied within 60 days. Now the central bonded warehouse says that, look, this product is not available with me. It will take 60 days to give it to you, but you can take this product, which is available currently, and you can take it off. This is immediately something that will impact my demand. Now here, if you lordship then see 10, very significantly, the central bonded warehouse shall have a minimum stock of all types of brands for 3 months. Now what is the minimum stock? Not mentioned. All types of brands for 3 months, how this minimum stock position will be determined? Not mentioned. So it makes it completely arbitrary, which ultimately means that if you today have a minimum stock of 3 months of liquor, then if a bonded warehouse approaches you, you should be able to give it immediately. Then you should not have to make him wait for 60 days. So you have a minimum stock of certain products, which you say you can take right away if you need it, but other products, you create an artificial scarcity, and so I don't have this, you have to wait for 60 days to get it. Well, which means the market is immediately affected. So all these points we have highlighted in some detail in our affidavit, which I have already placed before Lordship. I do not wish to waste your Lordship's time on this. May I just show Lordship, what the law on the subject is now?
Yes.
Here, so far as this is concerned, if your Lordship will kindly see,
Well, the first judgment that I'd like to draw your Lordship's attention to is the case of Korea Distilleries. Well, this is reported in 1995, Volume 1, Supreme Court Cases 574. Now, well, the question that fell for the court's consideration is, whether liquor would be res extra commercium. If so, what are the powers of the state vis-a-vis the dealings with liquor? Now, may I request your Lordships to please straight away come to paragraphs first 55. Do your Lordships have the judgment? Yes. Well, may I request your Lordships to kindly have a look at paragraph 55. The contention that if a citizen has no fundamental right to carry on trade on business in portable liquor, the state is also injuncted from carrying on such trade, particularly in view of the provisions of Article 47, were apparently attractive is fallacious. The state's power to regulate and to restrict the business in portable liquor impliedly includes the power to carry on such trade to the exclusion of others. So, the state can do it. Prohibition is not the only way to restrict and regulate the consumption of intoxicating liquor. The abuse of drinking intoxicants can be prevented also by limiting and controlling its production, supply and consumption. The state can do so also by creating in itself the monopoly. Creating in itself, Malatani notices, the state can also do so by creating in itself the monopoly of the production and supply of liquor. When the state does so, it does not carry on business in illegal products. It carries on business in products which are not declared illegal by completely prohibiting their production. But in products, the manufacture, possession and supply of which is regulated in the interest of health, morals and welfare of the people. It does so also in the interest of general public under Article 19(6) of the Constitution. Thereafter, your Lordship will kindly look at paragraph 56. The contention further that till prohibition is introduced, a citizen has a fundamental right to carry on trade or business in portable liquor has also no merit. All that the citizen can claim in such a situation is, Malat kindly notes this, is an equal right to carry on trade or business in portable liquor as against the other citizens. He cannot claim equal right to carry on the business against the state when the state reserves to itself the exclusive right to carry on such trade or business. When the state neither prohibits nor monopolizes the said business, the citizens cannot be discriminated against while granting license to carry on such business. But the said equal right cannot be elevated to the status of fundamental right. It is also no answer against complete or partial prohibition of the production, possession, sale and consumption, etc. of portable liquor to contend that the prohibition, where it was introduced earlier, and where it is in operation as present, has failed. Then after that, if your Lordship sees, Malad 59. The 1956 Resolution of Industrial Policy adopted by the central government also does not help the petitioners, appellants, in their contention that the production of industrial alcohol as an industry has to be recognized, and all that can be done is to regulate the said production but not to prohibit it. Apart from the fact that the said resolution has no legal efficacy and cannot have effect of limiting the powers of the state to prohibit or restrict the production of potable alcohol, the resolution itself nowhere speaks against such prohibition or limitation. The licenses granted to the distilleries, breweries and wineries of potable liquor are valid, not so long as their production, possession, such and such a concern. Well, then paragraph 60, if your Lordship sees, well, I don't want to place the entirety of 60. Well, this says, we may now summarize the law as spelled out from the aforesaid decisions. Well, if your Lordship will kindly see, well, first of all, well, B, well, which talks about, my lord, products which are inherently vicious and pernicious, well, are res extra commercium. That is what B says. I'll just read it. The right to practice any profession or to carry on any occupation, trade or business does not extend to practicing a profession or carrying on any occupation, trade or business which is inherently vicious and pernicious and is condemned by all civilized societies.
It does not entitle citizens to carry on trade or business in activities which are immoral and criminal, and in articles or goods which are obnoxious and injurious to health, safety and welfare of the general public. That is res extra commercium. Outside commerce, there cannot be any business in crime. Well, here, of course, my lord, one can't say that, my lord, business in liquor is res extra commercium, because it's permitted but regulated. Then, if you will see, my lord, paragraph, my lord, E. For the same reason, my lord, this is, my lord, where we come in with Article 19.6. For the same reason, the state can create a monopoly either in itself or in the agency created by it for manufacture, possession and sale and distribution of the liquor as a beverage, and also sell the licenses to the citizens for the said purpose by charging fees. This can be done under Article 19.6 or even otherwise. So, my lord, state monopoly is permitted. Then, my lord, if your lordship will see F. For the same reason again, the state can impose limitations and restrictions on the trade or business in potable liquor as a beverage, which restrictions are in the nature different from those imposed on the trade or business in legitimate activities and goods and articles which are res commercium. The restrictions and limitations on the trade or business in potable liquor can again be both under Article 19.6 or otherwise. The restrictions and limitations can extend to the state carrying on the trade or business itself to the exclusion and elimination of others, and preserving to itself the right to sell licenses to do trade or business in the same to others. When the state permits trade or business in potable liquor, with or without limitation, the citizen has the right to carry on trade or business subject to the limitations, if any, and the state cannot make discrimination between citizens who are qualified to carry on trade and business. The state can adopt a mode of selling the licenses for trade or business with a view to maximize revenue, so long as the method is not discriminated.
Got it, Mr. Sir. But
Yes.
State can have a monopoly, but it cannot create a monopoly of a private.
Yes, my lord, I am very grateful. My lord, now, my lord, this coded distilleries, my lord, ultimately, my lord, found, my lord, a better reflection perhaps in, my lord, the Kerala Bar Association case. I want to show your lordship just 2 paragraphs of the decision. My lord, this is reported. In 2015, volume 16, Supreme Court cases, page 421. Well, may I request your lordship to kindly have a look at paragraph 30 and then paragraph 32. I want to show your lordship what was the argument before the court. Yeah. The next ground for challenge has been under Article 19. Learned Senior Counsel for the appellants, Mr. Sundaram, has sought to argue that a right under Article 19(1)(g) exists in the business of liquor. In his detailed elucidation of the decision in Code, he has contended the state is given 3 options. The first is prohibition. The second is a state monopoly in manufacture or trade or both in potable liquor. And the third, which is similar to the case at hand, is that the state allows private individuals into the business, in which event everyone would have a right to partake in it. Reliance was placed in Code Malad paragraphs. I don't want to trouble your lordship with that. Then Malad, kindly look at paragraph 31. Code also held that all rights under Article 19(1) of the Constitution are not absolute, as they are qualified by the respective clauses 2 to 6 of Article 19. Business in liquor is further regulated by the rigors of Article 47. However, the categorization of dealing in liquor as a qualified fundamental right cannot be interpreted to indicate that a right under Article 19(1)(g) does not arise. This is in line with the previous 5-judge bench decision in Krishan Kumar Narula, which, as we previously discussed, returned the opinion that a citizen can have a right to deal in liquor subject to reasonable restrictions in the public interest. Thus, since 5-star hotels are given a right to deal in liquor, all other categories of hotels can also claim on the grounds of Article 19(1)(g) subject to the reasonable restrictions allowed by Article 19(6). It has been contended that the restrictions imposed here are not reasonable for various reasons, including that relevant material has not been considered, etc. Then, my lord, kindly see 32. We disagree with the submissions of the respondents that there is no right to trade in liquor because it is res extra commercium. The interpretation of Khode put forward by Mr. Sundaram is, in our opinion, more acceptable. A right under Article 19(1)(g) to trade in liquor does exist, provided the state permits any person to undertake its business. It is further qualified by Articles 19(6) and 47. The question is whether the restrictions imposed are reasonable. So, the three limbs are absolute prohibition, monopoly by state, or others. If it's by others, then
illegal business or trade, absolute prohibition.
That's right.
And liquor is not treated to be one.
That's right. But unfortunately, the courts have used the expression res extra commercium for liquor, although it is ultimately confined to something that is a ban. For example, contraband article, intoxicating drug, even those are allowed. So, I don't know. The expression is perhaps a little, perhaps unpurposefully used, but then, this has been also the view, in other judgments. I will not place the judgments, may I? I shall of course put this in my notes of arguments. It's because of the paucity of time, I am just giving your lordship the citations. There are three other judgments that I would like to rely on in this regard. One is, the judgment in the case of Rashid Ahmed, that is All India Report on 1950 Supreme Court, page 163.
Oh, 1950?
1950 Supreme Court 163.
Yeah.
Yes, 1950.
163.
163. Then the next judgment, I shall put it in some details in my note. I know your lordships are constrained for time here, so I don't want to unduly drag it on.
Mr. Shah, you just give us the proposition, we'll read it.
Yes, the proposition is that ultimately it's the same thing. You cannot create a monopoly, which would ultimately be in violation of 19(6). Monopoly in the hands of the state is fine. This is Rashid Ahmed. For example, if your lordships will quickly have a look at paragraph 4 of the judgment, just one paragraph. The challenge made by the petitioner to the validity of the act and the relevant notifications is met by the respondent one, mainly on the ground that the Orissa legislature was competent to pass the act and its provisions do not contravene Article 19(1)(f) or (g). It is urged that under 19(6), the state legislature is empowered to create a state monopoly in any trade business, and the monopoly thus created cannot be successfully challenged either under Article 19(1)(f) or under Article 19(1)(g). In support of its case that the prices fixed under the Act and the scheme of enforcing the support of the enforcing state monopoly adopted by the Act are reasonable, respondent number 1 has referred to the previous legislative history in respect of Kendu leaves and has pointed out that the Act was passed in pursuance of state recommendations.
You're reading, Mr. Shah?
Well, I was reading paragraph 4.
Of 1950?
1950, my lord. If you will kindly see paragraph 1, my lord.
No, the paragraph begins with the word?
Well, the paragraph begins with the words, the challenge made by the petitioner to the validity.
It's a March.
The Supreme Court case is this. The challenge made by the petitioner to the validity of the Act.
Rashid Ahmed versus...
I'm sorry, my lord. I'm sorry, my lord. I have made a mistake. I have made a mistake, my lord. Kindly forgive me, my lord. Well, I am very sorry. Extremely sorry. It says the second part of the bylaw. I am very sorry, my lord.
No.
The second part of this bylaw clearly contemplates.
You have a copy? Any chance?
Paragraph 12. No, my lord. Kindly have a look at, my lord. I will be very brief. I should just show you, lordship, my lord. 3 or 4 lines in paragraph 2.
Okay, paragraph 10 of SCC version. The second part of this bylaw clearly contemplates that everybody
will be entitled to do business at the place fixed by the respondent board but as a result of a monopoly in favor of the contractor Habib Ahmed having been created, nobody else can do business at that place as conceded by the learned advocate for the respondent board. Under the first part of this bylaw, no person can establish a new market or place for wholesale transaction without obtaining the permission of the respondent board. This part of the bylaw clearly contemplates that the board may permit the establishment of a new market for wholesale dealings in vegetables. The petitioner applied for this permission, but it was refused. Bylaw 2 is still in force. If it requires a license, then under section 241(2)(a), the respondent board cannot refuse such a license except on the ground that the place where the market or shop is established fails to comply with the conditions prescribed by or under the Act. It is considered that the rejection of the petitioner's application was not based on any such ground, but it was because there was no bylaw authorizing the issue of any license. The Constitution by Article 1 guarantees to the Indian citizen the right to carry on trade or business subject to such reasonable restrictions as are mentioned in Clause 6 of that article. The position, however, under Bylaw 2 is that while it provided that no person shall establish a market for wholesale transactions in vegetables except with the issue of license, except with the permission of the board, there is no bylaw authorizing the respondent board to issue such license. The net result is that the prohibition of this bylaw, in the absence of any provision for issuing license, becomes absolute. Further, Bylaw 4 contemplates that the grant of a monopoly to a contractor to deal in wholesale transactions at the place fixed as a market. Acting upon that provision, the respondent board has granted monopoly to Habib Ahmed and has put it out of its power to grant license to the petitioner to carry on wholesale business in vegetables, either at the fixed marketplace or at any other place within the municipal limits of Kairana. This certainly is much more than a reasonable restriction on the petitioner as contemplated by Clause 6 of Article 19. This being the position, the bylaws would be void under Article 13(1) of the Constitution. So, even today in the matter of creating licenses, if you're making a discrimination, even that comes under the purview of challenge under the constitutional validity of Section 90, Article 19. Well, thereafter, is the decision in the case of Akadasi Pradhan. Well, this is reported in All India Report of 1963, Supreme Court 1047. What Pradhan is actually? So if your Lordship sees the last sentence of the first paragraph. It says, but since the Act was passed in 1961 and it came into force on 3rd January 1962, the state has acquired a monopoly in the trade of kendu leaves, and that has put severe restrictions on the fundamental rights of the petitioner under Article 19(1)(f) and (g). That is in substance the basis of the present petition. So only this was the subject matter of challenge. Then your Lordship will kindly come straight away to paragraph 29. We must now examine the validity of the argument urged by Mr. Pathak that the Act is bad because it seeks to create a monopoly in favor of individual citizens described by the Act as agents. For deciding this question, we must revert once again to the amendment made in Article 19(6). The argument is that though the state is empowered to create state monopoly bylaws, the trade in respect of which the monopoly is sought to be created must be carried on by the state or by a corporation owned or controlled by the state. There can be no doubt that though the power to create monopolies conferred on the legislatures is very wide, and it can be created in respect of any trade, business, industry or service, there is a limitation imposed at the same time, and that limitation is implicit in the concept of state monopoly itself. If a state monopoly is created, the state must carry on the trade, or the state may carry it on by a corporation owned or controlled by it. Thus far, there is no difficulty. Mr. Pathak, however, contends that the state cannot appoint any agents in carrying on the state monopoly, whereas the learned Attorney General urges that in carrying on the state monopoly, that the state is entitled not only to carry on trade by itself, or by its officers serving in the state, serving in the departments, but also by agents appointed by it in that behalf. And in support of his arguments that agents can be appointed, the learned Attorney General suggests that persons who can be treated as agents in a commercial sense can be validly appointed by the state in working out its monopoly. We are not inclined to accept either the narrow construction pressed by Mr. Pathak or the broad construction suggested by the learned Attorney General. It seems to us that when the state carries on any trade, business or industry, it must inevitably carry it out either departmentally or through its officers appointed in that behalf. In that very nature of things, the state as such cannot function without the help of its servants or employees, and that inevitably introduces the concept of agency in a narrow and limited sense. If the state cannot act without the aid and assistance of its employees or servants, it would be difficult to exclude the concept of agency altogether. Just as the state can appoint a public officer to carry on the trade on its business, so it can appoint an agent to carry on the trade on its behalf. Normally and ordinarily, the trade should be carried on departmentally or with the assistance of public servants appointed in that behalf. But there may be some trades or businesses in which it would be inexpedient to undertake the work of trade or business departmentally or with the assistance of state servants. In such cases, it would be open to the state to employ the services of agents, provided the agents work on behalf of the state and not for themselves. Take the case of cane leaves, with which we are concerned in the present proceedings. These leaves are not cultivated but grow in the forests, and they are plucked out during 3 to 4 months every year, so that the trade of purchase and selling them is confined always generally to the said period. In such a case, it may not be expedient for the state always to appoint government servants to operate the state monopoly. An agency would be more convenient, appropriate and expedient. Thus considered, it is only persons who can be called agents in the strict and narrow sense to whom the workings of the state monopoly can legitimately be left by the state. If the agent acquires a personal interest in the working of the monopoly, ceases to be accountable to the principal at every stage, is not able to bind the principal by his acts, or if there are any other terms of the agency which indicate that the trade or business is not carried on solely on behalf of the state, but at least partially on behalf of the individual concerned, that would fall outside Article 19(6)(2). Therefore, in our opinion, if a law passed creating state monopoly and the working of the monopoly is left either to the state or to the officers of the state appointed in that behalf, or to the department of the state, or to persons appointed as agents to carry on work of monopoly strictly on behalf of the state, that would satisfy the requirements of Article 19(6)(2). In other words, the limitations imposed by the requirement that the trade must be carried on by the state or by a corporation owned or controlled by the state cannot be widened and must be strictly construed. An agency can be permitted only in respect of trades or businesses where it appears to be inevitable and where it works within the well-recognized limits of agency.
Any other decision, Mr. Sharma?
One more, my lord. My lord, this is, my lord, the state of Rajasthan versus Mohanlal Vyas. My lord, this is reported in 1971, volume 3, Supreme Court cases, page 705. 1871. My lord, I request you lordship to have a look at, my lord, paragraph 6. Well, a very short paragraph. In 1951, there was amendment of the Constitution whereby Article 19(6) provided that the monopoly rights could be created in favor of the state in respect of any trade or business. The monopoly contracts in the present case were not in favor of the state government. Article 19(6) of the Constitution provides a reasonable restriction on the fundamental rights of citizens as contained in Article 19(1)(g). If the state obtained the monopoly, it would be defensible as a reasonable restriction on the rights of citizens to carry on any business or trade and to ply buses. On the other hand, if the state conferred any monopoly right to a citizen, it would be indefensible and impermissible and would be an infraction of the inviolable provisions of the Constitution. Well, on the aspect of similar trade in liquor, there are 3 judgments. Your Lordship has also kept the matter tomorrow. I can see the clock, I can cite those 3 judgments.
You'll be here tomorrow?
Yes, yes. Your Lordship has fixed it, for 3 days.
Same model as yesterday, huh?
Just 3 more judgments and I'll close.
And Mr. Baiji, you'll be able to start tomorrow?
Depending on how long it goes on.
Thank you.